Hey guys, it's Joel Williams and Chase ELLEBY with Williams ELLEBY coming to you this week with video number 35 out of our video series of 52 Weeks of Personal Injury. Today we want to talk to you about what I consider to be the most important part of a lawsuit, and that's the discovery phase. So Chase, before we get into the specifics of it, can you just tell us generally what discovery is?
Yeah, discovery is when you learn everything that you're ever going to learn about a lawsuit, right? So it's the time in the lawsuit, usually in Georgia state court, your kind of standard, case. Discovery lasts 6 months, and that's the time where you literally talk to witnesses, get documents and things like that, which I know we'll go into the specifics of it, but that's really the time where you learn about the case, the strengths and weaknesses and everything that comes along with that.
Gotcha. So during that discovery phase, most of the time discovery starts with written discovery. I generally think of written discovery in 3 parts. The first part, I think of interrogatories.
Right.
The second part, I think of requests for production of documents and things. And then, even though it's not technically discovery, there's also what we call requests for admissions. So what I want to do first is kind of go through what interrogatories are, what requests for production is, and what requests for admissions are, and kind of explain what their importance and purpose are. So why don't we start with interrogatories?
Yeah, so interrogatories are just written questions, right? So it's literally a list of questions for whoever you're sending them to answer. That usually starts with what's your name, where do you live, what's your birthday, all that type of stuff. So just interrogatories, written questions, that's all they are. And you've got 30 days to respond once you receive the written questions.
Yep. And the plaintiff will send them to the defendant, and the defendant will send them to the plaintiff. If there are multiple parties, there may be 3, 4, 5 sets of interrogatories that go out. Typically, those are sent very early on in the case, and they have to be responded to under oath. So the party responding to them has to swear that everything in their answers is true. Request for production of documents is similar, but instead of written questions, it's please identify and produce X, right? If it's a trip and fall case, maybe you're talking about producing the hazard itself. If it's a tangible object, producing video of the fall, all of that kind of stuff, incident reports, that kind of stuff. The defendant will send interrogatories or requests for production to the plaintiff. Typically that's going to be, produce, if it's that trip and fall case, some kind of documentation that you are of your status in the store, if you're an invitee or whatever. Produce copies of your medical bills, your medical records, anything else that may be pertinent to the defense in the case.
Right, yeah, it's documents and things, right? So like you said, it can be, objects, right? We've had cases where, like a slip and fall, they might ask our clients to preserve their shoes, right? So they can go and investigate and look at the type of shoes that our client was wearing. So yeah, it's documents and things. So the third thing that we just talked about were RFAs, requests for admissions. And those are simply, you basically send to the other side, they're called requests for admissions, and you ask them to admit or deny certain statements, right? Admit that you're properly served, admit that venue is proper, admit that jurisdiction is proper, all those types of things. It can streamline the case and just kind of take away a lot of issues that you don't have to focus on because they're already admitted. Another good example is in a clear liability car wreck case. Admit that you caused the wreck, admit that the plaintiff didn't do anything wrong. If they admit, you can kind of set that to the side knowing that you're not going to have to deal with those issues.
Yep, kind of helps narrow the issues that are going to be contested during the lawsuit. Another type of written discovery are written requests to non-parties. So, for example, in a personal injury case, the defendant's likely to send non-party requests for production to the plaintiff's treating providers to find out, did the plaintiff give me all of their medical records, and get them directly from the source. In a car wreck case, if we are suspicious that somebody may have been texting while driving or something like that, we may send non-party requests for production for the other side's cell phone records. Tractor-trailer case, same type thing. We may send non-party requests for production to previous employers of the tractor-trailer driver to find out more about their driving record. So you can send those non-party requests for production of documents and things to people who aren't even involved in the lawsuit, and then they have to respond as well.
Right, that's exactly right. So another part of the discovery phase, which I think is probably the most fun, are the depositions. And that's literally just your opportunity to sit down at a table. Well, now a lot of them are done via Zoom. But to ask the other side, whether it's the at-fault driver, a store owner, a 30B6 representative, which is basically a person who speaks on behalf of the corporation, that's just your opportunity to ask them questions about the incident, about the wreck, about the slip and fall, about the medical malpractice, whatever it might be. And it's done under oath, and it's usually lasts, a few hours depending on who the witness is. And you can depose really anyone that you think might be relevant, not just parties to the case. It can be witnesses, it could be the investigating police officer, it could be doctors, all those types of folks.
Yep. And if you're interested in learning more about depositions, we do have a video that we'll put a link to here that kind of dives more in depth into depositions. And if you're being deposed, that might be really useful to you, so you can learn how to conduct yourself during the deposition itself.
Right. All right, so what happens during the discovery phase when you don't get a response to the question, they freeze in a deposition, they don't give you documents? What can we do in those situations?
Yeah, so at any time during the discovery phase, something can go off the rails. You get unsupported objections, the other side's withholding documents that you think that they should have and they're not giving to you. They're refusing to answer questions or whatever. So in those situations, you're supposed to confer, at least in Georgia, with the other side, try to work it out. Sometimes that works, most of the time it doesn't. So what you have to do is file a motion to compel. That's a motion that you file with the court, asking the court to order the other side to produce those documents and things, or to answer the questions that have been asked. And then if the court grants that motion, then the other side has to do it. If they don't do it, the court's going to sanction them.
Right.
But there are situations where one side may insist on the production of certain things, but you really feel like you have a good reason to not give that. In that situation, you file what we call a motion for protective order.
Right.
That's when the side that's supposed to be producing the information or documents or answering the question asks the court to protect them from having to provide that information. So those are the two major motions that you may run into in discovery. What's next?
Another thing you can ask, the other side, if there's, say it's a bad wreck and it's a tractor trailer and you want to go and see the tractor trailer, you can request to inspect that vehicle, request to inspect the premises, take an expert to do measurements and things like that if it's a trip and fall or something of that nature. So you can always ask the other side to inspect. Usually in cases too where you're going to inspect something at some point, you'd send a spoliation letter, which is us telling the other side, hey, hold on to the vehicle before you trash it or before you repair it, or make sure you hold on to video if there's video and things like that. So going in and inspecting the premises, inspecting a vehicle is always also another aspect of discovery.
Yeah. So I think all in all, as far as discovery is concerned, the reason that I believe and that we believe it's really the most important part of a case is because it really is the time in a lawsuit where you have the opportunity to discover information that you don't have the opportunity to discover at any other time.
That's right.
So as private civil attorneys, we don't work for the government, we work for individuals. So we don't have subpoena power or the power to issue warrants or anything like that. So sometimes there's documents and things or video that we can't get until a lawsuit's filed and we have the ability to subpoena the corporation or the other individual and make them produce that stuff.
Yeah.
So it's easy for attorneys and litigants to take discovery for granted, and especially in cases where it seems pretty straightforward. But I would urge anyone that's involved in a lawsuit, whether you're the plaintiff or the defendant, to take advantage of the opportunity you have during the discovery phase to learn as much as you possibly can about the other side's case. Because when you get to trial, you don't want to be surprised by anything. And if you've done a good job in discovery, you shouldn't run into any surprises that are going to tank your case in front of a jury.
Yeah, absolutely.
Anything else about discovery?
No, I think we talked about most everything. So.
All right, cool. Well, we appreciate your time today. If this video has been helpful to you, please give us a thumbs up or subscribe to our channel. Otherwise, we will see you next week for video number 36 out of our series of 52 weeks of personal injury.